Before we dive into today's agenda, and we do have a lot here for you, looking at the current state of U.S. privacy laws and looking ahead, the different updates that are coming down the pipe, and also looking at the different trends and concerns that companies are facing, and some tips on how to stay compliant. And before we get started, we do want to understand what is top of mind for you. So we do have a couple of just quick poll questions to help help with that. First, what laws are concerned impacting your day to day? All right,
Mm,
California is still top of mind with the other U.S. state laws. But Washington is definitely top of mind for a lot of folks, and we'll get into why Maryland it may be one that is concern of folks as well here in a little bit. All right, and for our second poll question, what emerging U.S. laws are you following? Because there's a lot going on, which Kier will definitely get into. Whether it's at the federal level, laws concerning AI or biometrics or children's privacy. All right, seeing what's going to be happening at the federal level is definitely top of mind of folks. And no surprise as AI continues to be a key topic, top of mind for many companies. And no surprise they're looking at, what is going to come out of the legislative environment around AI. All right, let's dive into our what is the legislative environment looking like? Kier, you want to let us know what is the current state? What are you seeing? You're monitoring this from the legislative perspective, looking at this, as soon as bills are being introduced and you're tracking them all the way through. So,
sure.
what
So I think it's a really great time to ask this question because we are nearing the end of the majority of the US state legislative sessions. So it's a good time to kind of pause and reflect and get a sense of where we are at currently in the overall state privacy landscape. And I'll turn first to the so-called comprehensive state privacy laws, which are those that seek to set kind of generally applicable guardrails around the collection, use, and sharing of personal information across the economy. So far this year, we have 4 new states that have adopted these comprehensive privacy laws. Those are New Jersey, New Hampshire, Kentucky, and Nebraska. And that brings our sum total of state privacy laws to 16, if you don't count Florida as a comprehensive privacy law, which you really should not. We also do have a bill that's currently pending the governor's signature in Maryland, which we will discuss later. And over the next couple of weeks or even days, we are quite close to also potentially having new comprehensive privacy bills pass in both Minnesota and Vermont. So looking ahead to new laws that will take effect over the course of this year, we have Oregon on July 1st, which for the first time will require that organizations reveal the specific third parties with whom they share personal information, not just the categories of third parties. So that's a big transition. It also lacks common carve-outs for pseudonymous data. And so I think Oregon has really been a little bit under the radar as a potentially significant new state privacy law soon taking effect. Also on July 1st, we have Texas taking effect, which will, for the first time for a state comprehensive privacy law, place certain obligations on small businesses, specifically to obtain opt-in consent for the sale of sensitive personal data. And then finally, later this year, we have Montana taking effect on October 1st. And this is essentially the Connecticut state privacy law. But it is very interesting to see such a strong framework be enacted in a red state. A bunch more laws taking effect in 2025 and 2026. But for our purposes, we can call those next year problems for now. I'd also like to touch briefly on sectoral state legislative activity. And here I think the really big news is that the Washington State My Health, My Data Act is now in effect and enforceable. It has been in effect for about a month. It applies to a very broad range of companies and covers a very broad range of consumer health data, including information that is not typically thought of as health data. It does things like require companies to publish a separate consumer health privacy policy. So you may already have seen additional clutter popping up at the bottom of web pages as you browse the internet. It's also unique because it has two tiers of consent. Kind of regular opt-in consent for data processing activities that aren't necessary to provide a requested product or service, but also this new heightened consent tier of affirmative authorization for data sales, which likely includes the transfer of data for current targeted advertising practices. And this seems like a very burdensome consent mechanism. And I haven't actually seen an example out there in the wild of an affirmative authorization consent flow. And very importantly, this law is one of our first big state privacy laws since the Illinois Biometric Information Privacy Act way back in 2008 to actually include a private right of action. Not a private right of action for statutory damages, mind, but a PRA that is tied to the state's existing Consumer Protection Act, which does require a showing of injury to business or property in order to recover damages. So we haven't seen any lawsuits filed yet, at least I haven't, for this new Washington state health privacy law, but that does seem like something worth paying close attention to in the future. There's a similar health law that has also taken effect in Nevada that doesn't have a private right of action, and I would also be paying close attention to a similar bill that is moving through the state legislature in Illinois as we speak. There's also been plenty of activity around youth online privacy experiences and legal challenges to those legislative attempts. Red states continue to pass laws that seek to regulate social media platforms and require these social media sites to conduct age verification of their users, as well as to require that youths obtain parental consent in order to open an account. In blue states, however, there has been recent activity on a new version of the Age Appropriate Design Code Act. This was a law that was adopted in California and then temporarily, for the present, enjoined on First Amendment grounds. However, there is a new version that seeks to avoid some of the constitutional infirmities that befell the California model, such as those age estimation requirements that I was discussing. And one of these laws is awaiting signature currently yet again in Maryland. And we also do see Colorado is very close to amending its underlying state privacy law to add new children's protections, very similar to what Connecticut did with a Senate Bill 3 last year. And then just really briefly, finally, pay attention to an upcoming rulemaking process in California that is likely to initiate this summer, which is going to create new rules under the state's consumer privacy law for things like cybersecurity audits, risk assessments, as well as opt-out rights with respect to automated decision-making technology, which appears set to go much, much further than comparable requirements in other state laws. And this is an attempt to create opt-out rights for things like first-party online advertising, not just third-party cross-context behavioral advertising, also a right to opt out of things like intrusive profiling in public places or in the context of a student or an employee, as well as an ability to opt out of the use of individual data for training AI systems. So that's going to launch this summer. It may take a year to finalize, but California is going to continue leading the charge in many ways when it comes to our overall state privacy landscape.
Oh, absolutely. California does like to lead the way on that. And Kira, thank you for that comprehensive overview of what is going on. As you can tell, it's a lot. And Scott, in your practice, especially in a large law firm with a privacy practice, what are your clients? What are you seeing? What are you following?
Yeah, so it's an area that is evolving constantly, right? And so Kier just kind of went through a high level overview of where we are today and what we're anticipating. I know we're going to talk more about what we're anticipating, but it's clear just looking at the map and then listening to Kier's comments, this idea that you can anticipate how your business is going to be impacted by each of these laws has become a lot more complicated. So my health, my data, which we'll talk about, I think, one of my favorite topics these days, is a good example how you might not be a healthcare data. Kier gave you just a general overview of it. I'm sorry, you might not be a healthcare company. You might not be dealing with healthcare data as you define it, but you very well may be impacted by the law as it's being not only as it's coming online, but as it's going to be enforced within the state of Washington. So I generally, say to clients, this is a mess for a country that arguably founded itself by the rule of law with certain privacy principles, right? They're right in the First Amendment. Then, you think, how are we 200 plus years later just finally wrapping our arms around privacy rights in this country at the state level to the level we're dealing with? Now, one of the easy arguments is data has become maybe a modern version of the gold trade or the oil industry. It's an asset to many businesses. But it wasn't that long ago that clients, doing deal work were wondering, is my data an actual asset? And can I actually value that data if I'm doing a deal or if I'm licensing it, et cetera? Well, it's clear today that for most companies, it is an asset. But what Kier just described and what this map illustrates is that valuing your data and your risks and opportunities with respect to obligations and opportunities for its use has become a lot more complicated and is going to stay complicated. I know we're going to talk about the federal initiatives, but I don't see those initiatives solving the mess that Kier just summarized.
Right. And with the number of the laws and the environment we're seeing with the states, there's a lot of different approaches that the states have taken with these different laws. And for example, some, cover employee data. I think California is the only one that covers employee data. Some cover B2B data, which California does. Kier, I'm not sure if some of the other states call it B2B data or if it's focused just on consumer data. It's one of the questions that we've gotten. But what are some of the other differences you are seeing? Especially, Maryland is being called out. What makes that one so different from some of the other approaches, the approaches that we've seen across some of the other states?
Sure, that's a great question. And to zoom out a little bit, entering this year, the big distinction in the comprehensive privacy landscape, so not talking about things like the Washington My Health My Data bill, was between California and the rest of the states. And the rest of the states generally followed what we call the Washington State Privacy Act model. So while there were significant differences between the other states, they all, generally speaking, adhered to the same kind of common framework and shared many key definitions, although some would go further or not so far as others. Lots of people tend to claim that California is the strongest of these state privacy laws, and there are definitely legitimate reasons to make that case. It has a very well-funded regulator just for the privacy law, which also has broad rulemaking authority, which we typically don't see in other states. It is also, as you mentioned, the only one of these state laws to actually apply to employee and business-to-business data, though it does seem like that may have been a drafting accident, but it's something we now have to live with today. It also does have a private right of action, though one that is very narrow, tailored exclusively for data breaches, and it is also much more prescriptive than the other state privacy laws, which does raise numerous compliance challenges, and there are already 50 plus pages of regulations implementing the California CCPA, with many more on the way. However, California is also weaker than some of the other state laws in significant ways, particularly with its right to delete, which only applies to data collected directly from individuals, when other states typically have a stronger right to delete. It also has a weaker treatment of sensitive data, creating only a kind of narrow opt-out right with respect to sensitive data, and then sensitive data only used for inferences. Most other states have opt-in consent requirements for collecting and using sensitive data and recognize sensitive data as inherently sensitive by its nature. So those other 15 states follow the Washington Privacy Act framework. They have these stronger deletion rights, opt-in consent requirements for sensitive data, and do go further or not as far as others in some significant ways. But for the most part, entering this year, it did seem like most organizations could build out a compliance program that could encompass most of these state privacy laws, although it may be kind of complicated or difficult in some ways. However, in getting to the thrust of your question, this year, what I call kind of the Pax Washingtonia has been thrown into disarray with the passage of the Maryland Online Data Privacy Act, which again is awaiting the governor's signature and could represent a new model for state privacy protections. Why is that? Well, largely this comes down to its approach to data minimization. While most of the other states lean heavily into consent requirements, either opt-in or opt-out, Maryland seeks to create first-order restrictions on what data can be collected and ultimately used. Under this proposal, the collection of personal data would be restricted only to what is reasonably necessary to provide a specifically requested product or service, and processing, which is broader, of a sensitive personal data would be restricted to only what is strictly necessary to provide one of those specifically requested product or services. Note, though, that these terms, reasonably and strictly necessary, are not defined under the law. And these are provisions that are still placed within an overall Washington state framework, which does contemplate consent for secondary uses of data. So there are some internal tensions here, and there are questions about how these will ultimately be resolved, implemented, and at the end of the day, enforced. There are additional differences. Sales of sensitive personal data would be strictly prohibited, not subject to opt-out requirements. There's a new knowledge standard for rights with respect to child users, and there are questions about whether or not that could create something of an affirmative duty to try to determine the age of your users. There are new digital civil rights provisions in Maryland that seem to be taken from the federal privacy proposal, the ADPPA of 2022. And then finally, the data protection impact assessment requirements in Maryland seem to be a little funky. They may be narrower than the other states in some ways, but also seem to require the assessment of individual algorithms. Could be hundreds or thousands of algorithms at play just in us having this conversation over Zoom right now. Algorithm is not defined in the bill, and I think there are big questions about what that is going to look like in practice. So definitely Maryland, assuming it is ultimately signed, none of these bills have gone through and been subject to a veto yet, is something that I definitely encourage the privacy pros to have on their radar.
All right.
Joanne,
great.
can I just make a illustrative comment there?
absolutely.
So let's take that last comment from Kier about doing a data impact assessment on algorithms. So if you venture into now like the AI discussion, which obviously is data driven, these are typically not static algorithms. Even in the most simplistic form, they're not static. So you could do an assessment on a Monday, and by Friday, that assessment that you did on Monday is completely irrelevant. And it's not just completely irrelevant because its use case might be different, right? That would be obvious. Today, we're going to use it for this, and tomorrow we're going to use it for that. Okay. But the input of the data that you previously put into the algorithm, and that's now feeding the algorithm within your organization, is likely different between a Monday and a Friday. And so doing that assessment on Monday, to me, has very little utility by the time you get to Friday. So it leaves this question in your mind of, okay, well, some of this is relatively easy to digest within your organization, but some of it actually is nonsensical to how you're supposed to address it within your organization. So it's just a good point that Kier was making about the complexity with some of these laws, and these little differences are making it really hard for businesses to figure out, okay, what's the bottom line for compliance?
Yeah, and data minimization is already a challenge with AI and how you train your AI models. And Eric, you're talking with our customers every day and working with companies, that are thinking through these and needing to deal with this. What are some of the key trends and main concerns that you're seeing and hearing about as organizations are working to comply with these different laws, and especially with these different approaches?
Absolutely. I would say a huge challenge that's on the top of a lot of people's minds is definitely how are you going to manage those different external channels as well as internal workflows and sort of operationalize the different sorts of requirements that we'll be seeing among these different laws. As Kier points out, of course, we've got these different buckets of general approaches, Washington model, California model, maybe a new model with Maryland. But there are a lot of little moving parts and little specific pieces that are going to impact stuff like DSAR, perhaps cookie consent, consent management more generally, all of those sorts of things. So for example, thinking about how do we word our privacy notice even? How do we filter those buckets? When we saw with GDPR is, of course, okay, now we have EU and then the rest of the world. And then say California comes on the scene. Now we have EU, California, everywhere else. And becoming even more sort of split, if you will, as new international regulations come along as well. So really thinking about how do we ensure that we are following the rules for these different use cases in these different states, and how are we managing that sort of external communication with things like the privacy notice. Even making decisions about how are we going to separate these things. Certainly some orgs have taken an approach, again, post-GDPR, that, okay, we're going to offer baseline, very basic DSAR rights, for example, to everyone, because sometimes it's just simpler, honestly, to do, okay, basic access, basic correction, basic right, to request deletion. Others have taken very siloed approaches where we have, okay, here's California that lives in its own space, here's EU that lives in its own space. But that approach, I have to anticipate, is going to become more complicated as we get more things, because certainly you're not going to have 16, 17, 18 different sections of your privacy notice to really drill explicitly down into each of these different regulations. So definitely managing those small differences and operational differences, I think, will be really important. As we touched on already, data minimization is a big concern, both on the federal US level, on the AI levels more specifically, and in a lot of these state laws especially. So really thinking about how do we manage the data that we need? How do we define and justify and have that basis for the data that we need when the existing landscape sort of up to this point has really been perhaps let's get as much as we can, and then we'll think about maybe, oh, do we really need it? Like, let's make sure we have it just in case, a little bit kind of mindset. So really thinking about defining those parameters, and particularly with AI, of course, thinking about the training, thinking about machine learning, and really kind of how do we rein that in to comply with these different, minimization principles. Certainly enforcement is going to be interesting because we've got a lot of different enforcement models. There's different regulators that are going to be set up. They're going to take different approaches and have different priorities, if you will, certainly. And of course, we can take sort of key observations away from what the existing regulators are doing, like, for example, CPPA in California, and perhaps even honestly taking some cues for the FTC in terms of what are these big things. With the FTC, it's things like data brokers, it's things like healthcare. So I think we'll see a lot of those sorts of things mirrored, and then really determining, okay, how do we balance this kind of very scattershot sort of thing as well. And finally, I'll just quickly touch on, since we've talked about Washington, we've talked about Illinois a little bit as well, but how do you balance those sectoral laws as well? How do we determine what triggers, okay, say we've got these 5 or 6 things, how do we balance those? Certainly, if you're a healthcare company, including those that fall outside of HIPAA, that's a very important distinction to make as well, as we're seeing with a lot of these FTC actions. Maybe you have wearables, maybe you have mobile apps. It is really a broad definition, particularly in Washington, as to what counts. So really making sure, okay, we're being granular with how we think about like our data inventory and data mapping, like what is going to be counted as healthcare data, because it may not be what we traditionally think as falling in that bucket. And finally, maybe I'll let Scott talk more about this one, but certainly risk of litigation and private rights of action. We've already seen that in California. We're seeing that in the Illinois Biometrics Act, and predictably, we may see it coming up in the future as well. So really thinking about, obviously, risk and how that's going to come into play. But again, maybe Scott can speak more to that point.
Yeah, and I think that's a great segue. Scott, what are you seeing in the litigation environment? What are you seeing as, coming next at the state law level, and some of the key trends and concerns that your clients are facing?
Yeah, so it's obviously a far-reaching topic, right? And you could spend a couple hours on where we are with this. Let me just talk about a couple of things. One, the private right of action. It gets a lot of attention. And it gets a lot of attention, including if there's a federal privacy bill and whether it will preempt state law and whether it will or won't include a private right of action. We know in some of the state legislatures, this idea of whether to include a private right of action has been debated. It's been a significant issue. And what I would say is we haven't seen in the comprehensive laws a real private right of action yet that's particularly alarming. The My Health, My Data that Keir referenced earlier, I think is going to be probably the one that gets tested. Illinois, of course, has a private right of action in their BIPA, their biometric law. And right now, on any given day, there's typically about 200 plus of those lawsuits pending in state court or federal court in Illinois. So maybe that's the direction we're headed. But I think there's maybe a more complicated problem that is immediately on the horizon. So when GDPR came to the US, a lot of us joked, well, geez, this is just the Europeans once again trying to impose some sort of tariff on the United States. Like, let's go back to the 1700s and their Stamp Act, right? And in a way, it really was. It was a similar approach where they were looking to protect the rights of their individuals and their residents versus others. Okay, fine. And we got a lot of questions about what do we do with GDPR? Should we apply it across the company? Should we apply it globally? And this problem that was presented then with respect to litigation is only getting more challenging to navigate here. That problem is if you extend rights through, say, a privacy notice or through any kind of contract to an individual that doesn't otherwise have them, then they arguably have a right to come back and try to seek to enforce those rights against you, the company. Now, I understand that's a pretty big brush of the stroke with respect to, say, GDPR. But back then, it seems like an eternity ago, the FTC was clear that if you are a US company and you're granting GDPR rights to US residents or citizens, then we're going to enforce under Section 5 our rights to make sure you're actually providing those rights as you so say. The challenges we have here, as Keir and Eric were just summarizing with respect to the variances between the state laws, is if you say, well, California is going to be my baseline, does that work anymore? Because how that plays out is, okay, well, one, am I complying with, say, Maryland? I don't know. I'm going to have to actually figure that out. But two, if I'm applying, say, California to a nationwide population that's interacting with my website or interacting with the data I sell, then my purported class in a lawsuit is no longer limited to California. It's now a nationwide class, right? So it's all consumers who otherwise might not have California rights, who now are looking to enforce California rights. So you go from a population of this, even though California is big, to a population of this. And that drives up litigation costs. But most importantly, it drives up the incentive for plaintiffs' counsel to file class action lawsuits saying, you didn't afford me these rights. Now, you get back to the private right of action. Can I actually sue? Well, you might not be able to sue under the applicable law. But if you have a disclosure or an agreement that says we will comply with all applicable laws, it's no longer me enforcing California. It's now me enforcing a contract or a representation that I based my decision to do business with you on. So, we've seen an enterprising plaintiffs firm in the privacy space, one of the more notable ones, take a position on this in healthcare. We successfully defeated it for now, but their idea was HIPAA does not have a private right of action. It's frustrated the plaintiffs bar for years. They've tried to figure out crafty ways to use HIPAA to bring a lawsuit, right? So you have a security breach. HIPAA says there's a security rule, you violated it, but you violated my trust, that's negligence, etc. What we see some plaintiffs' lawyers trying to do around this space is to say, okay, you had a statutory requirement to do X, Y, Z, whether it's under Maryland or Virginia or Connecticut, whatever law it is. You didn't meet that. We had an expectation that you were going to comply with the law, and therefore you were negligent, right? This is where the idea of a duty starts arising in privacy litigation. It's incentivizing more plaintiffs' lawyers to come into this space, and I think we're going to continue to see a high volume of lawsuits, and we're going to see, I think, more sophisticated counsel coming into the space, gearing up for bigger lawsuits, meaning bigger paydays and bigger defense costs. So those are some of the things that we think are on the horizon. I'll give you one example. This is outside of the, say, comprehensive privacy law space, but New Jersey has a law that seeks to protect information about judicial officers or law enforcement officers and their families. There are something north of 200 lawsuits that have been filed in the last 3 months, largely against data broker-ish companies, so big volume data companies, ones you've heard of, ones you haven't heard of. And what plaintiffs there are arguing is that these companies violated the statute and therefore they're entitled to statutory damages. The law was amended about 18 months ago. There's some squabbling about how that came to take place. The amendments kind of allowed for this latest wave of litigation. But what's most interesting to me about this relative to the comprehensive privacy laws is it is clear, and when I'm involved in some of those, that the plaintiffs' lawyers behind the cases invested time and energy to get a law in place that they could then seek to enforce with potential significant damages at the table. So they invested the energy to get there. It wasn't like a cyber matter where someone gets popped and then there's a lawsuit. This was an investment of effort. I think we're going to continue to see that.
All right. Lots happening on that front, and a lot of things for companies to think about is how they their strategy for complying with all these different laws. And Kira, what are you seeing from the legislative front? What are legislators thinking about on this?
Sure. So I'll start briefly on the private right of action question. Scott mentioned, I think it's Daniel's law in New Jersey. We do see maybe 2 or 3 other states coming close to passing very similar laws, potentially even this session. But on the other side, we've also mentioned the Illinois Biometric Information Privacy Act, and it does seem like we're moving towards a fix to that state law that would narrow the ability to recover statutory damages on a per scan basis. And so there's a bill, it's Senate Bill 2979, which is through the Illinois Senate and passed, I think, its first House hearing yesterday. Overarching question, though, looking ahead, what comes next? I'm a tech policy guy based in DC. I think I am legally obligated to answer this question by talking about artificial intelligence. But I promise I will try to actually know what I'm talking about here. And I think it's very, very interesting that we're seeing many of the individual lawmakers who were the first movers on some of these privacy laws are now leading the charge on proposals to set guardrails around the use of artificial intelligence. And I don't think it's obvious that that was necessarily always going to be the case. And I'm thinking here of leaders like Senator Maroney in Connecticut, Majority Leader Rodriguez in Colorado, and Assemblymember Bauer-Cahan in California. And so there are a lot of kind of questions and issues that are arising that many of these lawmakers are facing when it comes to how do we set protections around the use of AI systems. Question number 1, I think, is how do these existing privacy laws regulate AI? And Joanne, you already noted there are existing data minimization requirements that limit secondary uses of data. Well, that seems like that would encompass using personal information as for training sets. There's also questions about, okay, what are the uses of artificial intelligence that are actually high risk and most in need of guardrails today? And then what level of autonomy has to be offloaded to AI systems? So it is an algorithm or an AI system that is actually making a decision that brings them in scope of new laws like this. Also, how do you actually define artificial intelligence to encompass these complex systems that we care about and we're worried about, and you're not doing things like imposing new regulations on calculators or spreadsheets or GPS? And I think there's a ways to go in getting towards some artful drafting in this space. Now, the big question is, how do you divide responsibilities and what responsibilities are appropriate for the organizations that develop these high-risk AI systems versus the organizations that actually deploy these AI systems? And how do things like the development of open source AI models fit into that paradigm? Questions about when should individuals have the ability to opt out of being subject to a decision made by an algorithmic system, or when should they have the ability to challenge an adverse result from one of these decision-making systems, and also when is it even technically feasible to do so? And then what obligations should these organizations have to ensure fair or non-discriminatory outcomes for their systems? Should they conduct risk assessments, which we're familiar with in the pure privacy context? Set up a kind of data governance program? Should third-party independent audits be required? We've seen an attempt at that with a New York City law in the employment algorithm context. And then again, I think Scott made a really great point when it comes to talking about the regulation of algorithms, which may always be changing, learning, ingesting new data. And if you require a risk assessment and it changes, do you need another one the next day? How is this really going to work? Or when may a model actually substantially change, requiring a new assessment, and how do you determine that? So that's artificial intelligence, but I do think it's very related to the traditional privacy context. And we see California, its privacy regulator, is drafting regulations on this space. And again, many of the state lawmakers who passed these privacy laws that we've been talking about are the ones currently turning and advancing proposals to set new regulations for artificial intelligence.
Here, I have a question for you. You're very close to a lot of this, of course. A lot of us sit and criticize legislatures, either Congress or in the states, drafting laws that, one, aren't uniform or using different definitions and are becoming more and more complicated to just understand relative to, say, my business. How do you see that conversation happening with respect to regulation of AI? And I'll give you an example. So even in the practice of law, right? So there's copyright and IP lawyers who are saying this is an IP issue. And there's those of us who deal with data who are like, this is really a data issue. What's going into the machine? Those two groups would have probably very different views on how to appropriately regulate AI. And it's not clear to me who is actually doing the informing at the State House or within the hallways of Congress.
Yeah, I think that's a really great question. And I think AI raises many concerns that we see today. And I think it is interesting approaching this from a data governance kind of consumer protection issue in a lot of cases versus potentially what could be a copyright focused issue. Although Tennessee, I think, has passed some AI laws very focused on copyright, has a large music industry in Nashville. And yeah, I think we're moving into an era where not just privacy issues, but all kind of tech policy is increasingly being taken up at the state level. In the absence of the ability for the United States to pass sweeping federal kind of comprehensive laws. And obviously that's not ideal. The internet does not stop at state borders. That's obvious. But we also cannot begrudge like state leaders from stepping up into that void and taking immediate action to protect their own individuals. And I do think many of these lawmakers, the point of a patchwork or adopting divergent definitions are resonating. And so I think we're seeing more and more, as states increasingly step up to fill this role, more interaction between these state lawmakers taking places in forums like the National Conference of State Legislatures. We at the Future Privacy Forum do our best to convene many of these discussions and create spaces where lawmakers can talk with each other and learn at the same time. And I am seeing optimistic signs. Obviously, 400 plus state AI laws considered so far this year, many of them take very different approaches. But some of these really kind of key bills that have made significant progress, we do see some alignment around core definitions and key terms. That developer-deployer distinction that I mentioned, that's something that's coming up more and more. What is a controlling or substantial factor in making what it's a consequential decision? Many similar concepts here. It's still evolving. A big AI law has kind of yet to get over the finish line in one of these states. When it does, it may kind of it will probably influence what other states end up doing, because kind of passing a new big law typically means it's kind of gone through the ringer and all stakeholder groups have had an opportunity to weigh in.
Thanks.
Great, thank you, Keir. And you mentioned, at federal level, states tend to pass laws in absence of a federal law. So I'm going to ask each of you, kind of get a crystal ball, and what is the possibility? Just simple yes, no, and why you think so. Whether Congress can pass the American Privacy Rights Act. What do you think? The possibility of that happening anytime soon. Cure.
Oh, making me go first. I'm gonna avoid trying to put a number on the likelihood. Like, look, this is still a discussion draft at this point. It doesn't even have a formal bill number, at least last I saw. So it is clearly at the outset of what would be a very long legislative journey. In my view, the framework does seem to go further than anything we have currently at the state level. It takes a very aggressive and stringent approach to data minimization. It does have a significant private right of action that we haven't seen yet at the state level. It also has kind of new civil rights protections that we haven't seen at the state level in the data-driven context. So it's a long, long way to go, I would say.
Yeah, and Scott, what are your thoughts?
Yeah, I agree. I don't think it gets passed in its current form. I do think they're making progress, albeit slow progress. I mean, we've evolved from, discussions around proposed bills in Congress where, senators wanted to use negligence standards for criminal conduct, which is unheard of in this country. So we're definitely having a more mature conversation. This bill doesn't get passed in its current form.
Okay. And Eric, what are your thoughts on?
I'm going to give the classic answer of maybe and just agree with Scott, maybe with a lot of edits and change to the drafting. I think as we saw with the last probably couple of iterations of something like this, that there's definitely, especially after, for example, Maryland passes their law on the day after, okay, now we're pushing for this federal bill and maybe there's preemption involved. I think that is going to be kind of a hotbed of discussion and whatnot. Obviously, state legislatures and state regulators, the ones that have been set up, are very invested in their, state omnibus privacy laws, and it'll be interesting to see how that interacts. But I agree with Scott. I don't think in its current form. I think the hardline approach is going to be a little too hardline to be kind of palatable across the board. So I would expect to see major changes on that front. And then again, handling the question of preemption and handling how will that be taken given the ever-evolving kind of state landscape? So it depends. Everyone loves that answer right now, but it depends.
Can I talk about preemption just quickly?
Yeah.
So this idea of preemption is really fascinating to me. So if you look at the bigger privacy discussion that's happening in this country about whether it's Washington, D.C. or states that control privacy under our Constitution, there are other conversations happening from the Supreme Court. And this idea of preemption with respect to, say, website data, to me is one that's very complicated to have when you're not talking about the bigger picture of privacy under the Constitution. And that's one of the reasons I just don't think a bill that contemplates preempting states' rights would actually get through the legislative process.
Yeah. So you're thinking a federal bill should set a floor?
I think that's, so my own personal views aside, I think that's probably where you're going to end up and get both sides, the red and blue states, saying, okay, this is something we can live with. I think it's going to be very difficult to get both red states and blue states on board with this is going to preempt my state citizens' rights with respect to the handling of their data within my state. I think that's a complicated concept under US law that goes back a couple of centuries now. And I think, solving that question and that challenge in one privacy bill in Congress, I don't think that's going to work. And I think it's going to open up, if a bill includes that, to massive challenges that'll go right to the Supreme Court really fast.
Yeah, and I think that'll be interesting, if they do put out a bill that actually, sets floor, because I feel that would take us to a EU directive type model, which I know, GDPR was passed to kind of, simplify compliance with, the different laws in the EU. I mean, are we running that type of risk here in the US?
Yeah, maybe just I'll go first on that too. But at the time that GDPR came out, I think a lot of us criticized it, right? So we were, I kind of joked earlier about their influence on the world. I think looking at what they did back then, what's 5, 6 years ago now, relative to the situation we've created in the US, I would say GDPR is not such a bad solution. It certainly simplifies a company who wants to do business in Europe. It certainly simplifies their ability to access the market with a clearer understanding of what might be required. I'm not saying we should adopt GDPR, but it does simplify that relative to where we are right now. I don't know if others agree.
Yeah, definitely food for thought. And I know there's going to be a lot more discussion coming down the pipe as this continues to move through the process. Uh, Kier, what are you seeing in terms of, what regulators are looking at in terms of enforcement? Kind of what are some of the priorities are you seeing coming out?
Sure. Yeah, obviously an important question. And I think it is also important to underscore that we do have this new era of state privacy laws, but they are still kind of just starting to go into effect. 16, 17 now, depending on how you count. I think only 5 are like technically in effect and enforceable today. So all these laws we're talking about, organizations are still kind of on their compliance journey. And regulators are still on their enforcement journeys. And the ultimate impact of what this new era of state privacy laws at the end of the day is ultimately going to be, assuming we don't get a broadly preemptive federal privacy framework, is likely something that is going to unfold over the next 5 to 10 years here. And also remember that for many of these laws, even though they may be in effect, many of them also have a 2+ year grace period where there's a right to cure an alleged violation before reaching a final enforcement action, though a cure may not always be possible. But I think ultimately that means, and I think this is something that a lot of people really eager for strong privacy legislation in this country don't like, but it means that a lot of the initial enforcement activity for these privacy laws that we're talking about is going to be unfolding behind the scenes as regulators, typically the state attorney general's offices, send kind of enforcement letters and inquiry to regulated organizations. But we do have 2 final public enforcement settlements, both of which emerged from California out of the state attorney general's office. That was the Sephora settlement for $1.2 million back in 2022. And just this year, the $3,750 settlement with DoorDash. And both of the alleged violations there involved the use of online targeted advertising, data sharing for targeted advertising, and not giving individuals the needed rights in the correct way to exercise the right to opt out of data processing for that targeted advertising. So advertising in general, I think, is definitely a priority. Data brokers and sales of data that have been mentioned, also a priority. We're seeing that with the templates from the Colorado Attorney General's initial enforcement letters. California is also very interesting because they've started conducting certain kind of enforcement sweeps on sectors that we don't often think of as being the traditional targets of these privacy laws, the big tech companies. So this may not be a prelude to immediate enforcement, but California is certainly interesting in privacy laws in places like the connected vehicle context. Employee data, which we've already discussed, California is unique in applying these rights and protections to employee data, as well as the cross-device kind of streaming context on smart TVs and the like, not just on our computers. So those are the hints and trends that we've seen so far. The Connecticut Attorney General also released a very interesting kind of enforcement report maybe 3 or 4 months ago here, which is also interesting to read.
All right, great. And yeah, definitely a lot going on that front. Eric, what are some of the tips that you're giving customers in terms of, how do they, work to stay compliant? What are some of the things that they should be doing?
Well, absolutely. Obviously, step one is starting to think about which laws apply or may in the future apply to your business. There's a lot of different thresholds for kind of making that determination. There's a variety of different number of consumer thresholds, revenue thresholds, depending on where you're doing business or where you're physically located. So really trying to understand where, what is the landscape right now, meaning where would you fall into scope as of right now? And then thinking, okay, what about on that map that we had a couple slides ago, 2025, 2026, 2027, maybe even thinking really far out to really understand, okay, we need to get a handle and have a pulse on XYZ, like kind of triaging, if you will, because trying to comply with something like 16 different laws, frameworks, approaches at the same time is pretty overwhelming. So obviously starting triaging, what are the things right now? And then what are the things perhaps looking, 2025 to kind of take it in order.
Right.
Kind of along with that, tracking upcoming laws, of course. Obviously, FPF has a lot of great resources for that. TrustArc has some good resources as well. But keeping your finger on the pulse for what is coming. Again, what's coming right now, what's coming, a little bit sooner, what's coming in the farther future, to really make sure that it's not going to take you by surprise. Not that it could in privacy, since I feel like we're all kind of aware of all the constant pace. It's a very fast-paced sort of thing, but really keeping track of that. Obviously understanding the basic differences, and then for places that you are suspecting our org is going to fall into the reach of this particular law, on a more granular level, really understanding those basic differences and those overlaps where you can operationalize in a way that is going to ultimately simplify things. So if, pulling out of the hat, if, grabbing the bucket of states that are maybe taking the California approach, trying to think about how you can simplify what your operations are going to look like for that to kind of make, again, doing 16 different workflows is probably not going to be super efficient. So really thinking about what are the overlaps and what are the granular differences where we may have to build in something slightly different into those procedures. Which flows into this next point, really solidifying your approach to these different workflows per different state requirements. And this is a great time too, in general. You can never go wrong with trying to solidify your privacy position in general. All of the things we already know about the best practices for, like DSAR, cookie consent, retention, data minimization, all of those sorts of things, and certainly transfer to third parties and potential sell/sharing. So really locking that down, knowing where your data is, knowing where it's going, knowing what sorts of data might be kind of sucked into scope or suck you into scope for these different laws, really solidifying that approach, because there's a lot of unknown about a lot of these things, but there are a lot of things that we do know. Obviously, the laws that are in effect right now, we can get a good handle on those and know kind of what the initial forms of those are. And again, just our general best practices that we all already know, really hammering those down, really taking this as an opportunity to really mature those sorts of things, mature your privacy program, all of that good kind of stuff could never go wrong towards positioning you, for future developments. And finally, not forgetting about privacy notices and those external pieces. We've talked about ops, we've talked about workflows internally, but certainly externally, really thinking about how are we going to approach that individual rights section or choice section or disclosures about selling or sharing, or maybe for the states that take the California approach. We all know that the California approach for what needs to be in that privacy notice is very specific, and it's a little different from what your baseline best practice type inclination might be. So really thinking about how are you going to add those sections in? How are you going to organize, even just from a visual standpoint and a transparency and clarity standpoint, how are you going to sort of let consumers know, okay, this bucket applies to you when, X, Y, Z? And thinking again about, what might our baseline approach be so that we're ticking the boxes, at least the baseline boxes for, say, all of these things. The majority of these things, for example, have, again, some very basic DSAR commonalities. So really thinking about how do we align those? Are we going to go with give everyone these baseline rights and then sprinkle on top, if you're in California, these, if you're in Washington, these, things like that? Or are you going to go more siloed or more stratified, or maybe have some standalone notices for different buckets that maybe take the same approaches? So really thinking about how you're going to align that approach. And again, making sure that you're maintaining things like transparency, clarity, all those things that regulators are going to want to see if they're poking around your website and taking a look at your sort of public statements, to make sure that things are in line from that standpoint.
All right, great. Thank you, Eric. And as you mentioned, both TrustArc and Future Privacy Forum have a lot of great tools and resources to help you think about this. I think one of the key points to close with is something that Scott raised earlier, is also thinking through your strategy of how you're going to comply with all these different laws and the, impacts and the ramifications of that strategy, and looking through that. Scott, just any parting words on that point before
No,
we
I think it's
finish up?
critical. So no, nothing further. It's becoming more complicated. And I guess I would say, don't just think about today, think about where your business is headed in the next 18, 36 months too.
All right, great. Thank you. And thank you to my awesome panelists, Eric, Kier, and Scott. I really appreciate you sharing all this great information with us today. And with that, I thank our audience for joining us and taking an hour of your day to get up to speed on U.S. state privacy laws. Have a wonderful day.